Do you know the difference between the mediation and arbitration provisions in your contract? Hi, I'm Julia Way, a real estate attorney here at the law offices of Peter and Brewer. Today I'd like to cover some contract basics with you, specifically the mediation and arbitration provisions. Where do we typically see the mediation and arbitration provisions? Well, here in California, we tend to use the CAR or PRDS forms. There, at the end of the purchase contract, you will usually see the mediation and arbitration provisions paired together. In the form, what you'll notice, first of all, is that there is not a space for you to sign your initials in the mediation provision. That's because the mediation provision is intended to be mandatory. Failure to participate in mediation before bringing a claim could subject you to losing your attorney's fees even if you are the prevailing party. In contrast, the arbitration provisions do require initials. This means they are optional and the parties can elect to voluntarily participate in arbitration. The differences don't end there. First of all, mediation is a situation where the parties are going to come together in a voluntary settlement. That means even in working with a designated mediator, the mediator might be a retired judge, but the judge will not be imposing their decision upon you. The parties are going to come to a mutually negotiated resolution if they are able to settle their case through mediation. However, when you are participating in arbitration, this is essentially private judging. What this means is that the parties are opting to use a conference room instead of the courtroom, but everything else remains as if you were in court. That means there will be a panel who will be rendering the decision, and so this is an involuntary result, meaning it is not one where the parties came to some sort of agreement the way that you saw in the mediation situation. Once arbitration concludes, the result is an arbitrator's award, which can then be taken to court and confirmed as a judgment. There are some exceptions to the mediation and arbitration provision. Typically, if the amount in controversy is within the small claims jurisdiction limit, that would require the parties to actually have their matter heard through small claims rather than going through arbitration. Additionally, if a buyer has a specific performance lawsuit, they would typically need to record and file a complaint and get a lis pendens. So in that circumstance, also, they do not need to comply with the arbitration and mediation provisions first before bringing their action. To learn more about our firm and to read additional publications written by our attorneys, please visit www.brewerfirm.com.